car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into The Attorneys. Thank you so much for spending your Sunday evening with us. For the next half hour, we've assembled a panel of experts to deal with the subject tonight of divorce law, and we'd love to have you be a part of the conversation. To do so, all you have to do is call, text, email that information at the bottom of the screen throughout the program tonight. Leading our conversation, as he often does, from the firm Hollis Wright, is Josh Wright. Good to see you, sir.
Good to see you too. Hope you had a great week.
Indeed I did.
Number one, we got two things mentioned kind of in this little intro here. Number one of my dear friends who is an outstanding lawyer in the Gadsden area is with us tonight, Walt Buttram. First of all, Walt, we're so excited to have you on. Really appreciate you coming on. I have practiced law against Walt, which you don't want to do because he's that good.
Right.
I have practiced law with him in cases where we have been aligned on the same side, and he's just an outstanding lawyer that is a great member of our bar that's done some great things. So I'm super excited to have him on. Number two, we're talking about a topic that seems to really incite a lot of calls, emails, and texts in our shows.
Yeah.
And that today is divorce and child custody related issues. We're going to hit on some alimony things. And unfortunately, in today's world and society, we hear the statistics of 40% to 50% of marriages that are first marriages end in divorce in the first 5 years. Mm-hmm. It's obviously something that impacts a lot of the viewing audience. Right. And we hope you never go through a divorce, but if you do, and their child custody related issues, Walt Buttram's the guy that you want to be talking with to make sure you protect yourself and you protect your family and you do the things that you need to do. So super excited to have you on tonight, and glad that you're here to be able to talk about this great topic.
I'm glad to be here, and thanks for asking me.
Let's start just kind of generally. When does this, when someone comes to you, is it generally after a divorce has been filed? Is it to file something? I mean, how does it generally work with a typical client that you've got that will come to you?
Most of them come in before a divorce is filed. And there are some that come later because they're upset with their previous attorney, or their spouse gets an attorney and they didn't think they were going to do that, or whatever. But most of them are pre-divorce. How does,
I've heard this concept of Alabama is a 50-50 split state, or we divide marital assets 50-50. I know that's not accurate though. What is the law in that area? How does it generally work in divorce?
Well, we're what we call an equitable division state, and the way that works is that the trial court can consider all of the evidence that involved in the marital situation, the breakup, and whatever. And it can consider marital misconduct, and it can penalize a party for marital misconduct and whatever. And the thing is for the division to be equitable.
Mm-hmm. So the court has its discretion to be able to assist in that manner?
Yes.
So talk to me just in general terms for somebody that may be thinking about going through this process. How does the actual family court or the divorce court work insofar as it relates to the divorce itself? I mean, when someone comes and talks to you, what's the next step?
Well, the next step is if they want to file a complaint for divorce, we do the paperwork and we do the filing. And after that comes an answer to the complaint, excuse me. And after the answer to the complaint, somebody usually files a request for a hearing to be set.
Are all divorces, do they go to trial, or are some of them resolved before they get to trial? Because really divorce is no different than a typical lawsuit. If I file a personal injury case, for example, I've got a process where the case may settle early, it may settle at the time of trial, or it may go all the way through trial. Divorce works very similar, doesn't it?
Yes, it does. You can settle a case, you can try the case, you can mediate the case, whatever your parties really want to do. Personally, I always like for the parties to try to settle it if they can. If they can't, to try to mediate it, because they have more of the say-so, rather than putting something before a judge who makes an order and then they're stuck with what the judge says.
When folks first come to you, help us understand, what is your advice? Maybe they're not completely sure they want a divorce, but not happy and just trying to figure things out. What generally is your beginning advice, and what do you tell folks just to kind of help them decide if this is something that they want to do?
Well, especially if there's children involved, I always say look at the children, because they're the important ones. They're the losers. They're really the only losers in a divorce case. And you really have to act and do what's in their best interest, but you also have to take care of yourself. So I try to tell them, look, if you're unsure what you want to do, you need to take some time. You don't have to take long, take an hour, 2 hours, whatever, but get alone, think about what the situation is, make a decision for you, what's in your best interest, in your kid's best interest. Then go and act on that. I do have one other particular piece of advice that I always tell people who are in my office to see me for a divorce for the first time. And that particular piece of advice is that when your spouse starts talking to you about what's going to happen in this situation, you need to be careful and listen for 3 particular phrases. First of all is, I talked to my lawyer and my lawyer said. The second phrase is, my lawyer talked to your lawyer and your lawyer said. And then the third phrase is, my lawyer talked to the judge and the judge said. And the reason I tell them to listen for those 3 particular phrases, because whatever comes after any one of those 3 phrases is pure fantasy.
That's good. I think that's good advice. Mm-hmm. That's very good advice and very practical advice. Now, answer this for me, because I have not been through this process personally, but I have had friends that have. It appears like a very emotionally driven type of litigation. How do you manage the emotion and the expectations of how the emotions are handled through these lawsuits? Because I can imagine that can be just as complicated as the litigation itself.
Yes, it is, and sometimes the emotions are really, really high. It's not always the situation, and the only way I can deal with it is to deal with the person I'm dealing with, which is my client, and I try to help them and get them to take control of your emotions. Don't let them control you.
That's very good advice. And David, I know we're getting ready to go to break. I want to talk about child custody and how that process works, and how payments work and those types of things when we get back. But Walt is the type of individual who handles this type of litigation. He's a great resource to go to. I know there are people that are sitting on their couch right now that are watching this show saying, I really would like advice. This is a great time to get that advice. So I would certainly encourage people to call, text, or email today, because honestly, we can provide you good advice through that process, and Walt can do the same thing.
And that information, how to do so, is right there on your screen. Call, text, email, join the conversation. We're stepping aside, but we'll be right back as we head to break. A reminder, you can also find the firm of Hollis Wright on both Facebook as well as Twitter. Stay tuned. More of The Attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. Thanks for watching The Attorneys on WVTM 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the Attorneys link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys, talking about divorce law tonight. Would love to have you be a part of the conversation. Call, text, email. That information displayed on the bottom of the screen throughout the program tonight. Send us your questions, and we'll be sure to pass those along to our panel of experts.
All right, let's talk about custody, because I know that is a huge topic. We get a lot of questions about how custody is handled, who has the authority to change custody arrangements. And obviously with a lot of marriages, I mean, custody becomes one of the most critical issues when there are children involved. Just kind of give us a broad overview, if you will, and then I want to ask some specific questions, but kind of a broad overview of how custody works in general terms.
Well, in general terms, custody is in the court's decision there is what's in the best interest of the children, not of the parents or anybody else, but of the children. The court has to require joint custody in all cases, but that doesn't mean that the court has to award joint custody. The court can make its own decision as to what's in the best interest of the children based on the evidence that's presented in the trial. The joint custody statute itself has 4 definitions, and that's sole legal custody, joint legal custody, sole physical custody, and joint physical custody. The legal custody is the right to make decisions in as far as schooling, where they're going to live, such things as that. Physical custody is where the child actually spends time. The sole physical custody means that one parent or the other has the physical custody of that particular child or those children, and they live with that parent with visitation with the other parent. Joint physical custody is an arrangement where both parents have a right to have access to the child or the children and have time with them, significant time with them, but it may be just a visitation situation. Sole legal custody, as I said, is that particular parent has the right to make the life decisions for the child. And joint legal custody means that the 2 parties basically have to sit down and do it together if they can do that.
What are some examples of, when we talk about legal custodial or legal custody-based decisions, what are we talking about? Are we talking about academics? Are we talking about medical, those types of things?
Yes, the academics, medical, psychological, sometimes it's even their friends, who their friends are going to be.
So when we hear the term, we share joint legal and physical custody, that doesn't necessarily mean that the child is going to spend equal time with each parent, though, does it?
No, it does not.
And are there circumstances, Walt, where there are certain presumptions? I've always heard this presumption of, well, the mother has the presumption that she is going to have the most time with the child. Is that always accurate?
No, that's not accurate. There's not a presumption. The only presumption that the court is going to deal with is what's in the best interest of the child or the children.
Here's a question that I get a lot, and our show gets a lot when we talk about these topics. Does the child who's a minor, let's take a 7, 8, 9, 10-year-old child, male or female, do they have the ability to have input into whether or not they're going to live with the mother or the father? And does the court consider that kind of stuff?
Well, the magic number in Alabama is 14. At 14, the child has the right to say, I would like to live with mommy or I would like to live with daddy, and have that considered by the court as a factor. But the court is not bound by the child's desire. It all depends on what the court finds in the best interest of the child or children. We sometimes have judges that will listen to or talk with kids that are 11, 12, 13, depending on their maturity level. That's pretty much the way that goes.
How do judges or courts determine what is in the best interest of the child? What characteristics are they looking for in the parent that helps them determine, okay, he's going to be better off with the mother than the father? What are they looking for?
Well, most of the time what they're looking for is stability in the home, the economics of the situation, and what the kids want to do depending on their age. And
if the decision is made and whatever side's not happy with what it is, they don't feel like they got a fair shake in the deal, I assume it's not forever. You know, like if the custody, if the dad, one of the children as well, ends up with the mom, I mean, is it set for the remainder, or does the father have a recourse to revisit it in a few months, whether that's the best decision?
Well, either party has the right to come in and file a modification petition to change the custody arrangement. There's not necessarily a time limit, but my usual rule of thumb is I'd wait longer than 6 months.
Would you?
When you talk about custody, are there actual custody hearings where you put on evidence, present witnesses, do the things that you need to kind of establish who should have custody?
Yes, there are hearings, custody hearings. When you file a petition for modification, you do have a hearing.
All right, let's talk a little bit about some specific questions we get, because I know you'll be able to answer them for us. Let's assume the custody circumstance is set up. It's in some type of order from the court. One of the spouses wants to leave because of work or for other reasons, maybe another relationship. They want to leave the state and want to move, for example, to Mississippi or Tennessee or Georgia or something like that. Can they do that without notifying the other spouse? That is a question we get a bunch here.
Well, the answer to that question is no. They have to notify the other spouse. The legislature passed the Parent-Child Relationship Protection Act several years ago and states that if you're going to move, that's great, but you have to notify the other party. I think it's more than 45 days ahead of time, and you have to, in your notification, you have to give the address where you're going to be, the school that the kids are going to be in if you know what it is, your phone number. And if you don't know that, all that information has to be provided at some point. The other party has 30 days from the date they receive their notification to object to it if they wish to, and they can do that and ask for a hearing.
Another question we get a lot, Walt, is related to information. I'm not getting information about my child at school or legal issues. If there is a joint custody circumstance set up, do both the mother and the father have the ability to get that same information?
Yes, they do. There's a statute that provides that such things as educational, medical, psychological, dental, optical, all of those things, a parent has a statutory right to go and get copies of those records if they need them.
I know we're getting ready to go to break. When we get back, I want to talk about child support, because child support is a huge component to this whole process. When you've got a divorce and you've got custody issues, support is also a significant issue. We'll also throw some alimony in that I know Walt will be able to cover.
All right, we'll do that. Our final segment coming up, just a few minutes remaining. If you want to join the conversation, call, text, email. We'd love to hear from you. You get the questions to us. We'll pass it along to our panel tonight. Stay tuned. More of the attorneys coming right up.
I'm Tyler Vale with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this. The parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys. The final segment, just a few minutes remaining. If you have a question you want to get to us, now's the time to go ahead and do it, as we're talking about divorce law tonight. A question we have here, which is kind of interesting. I don't know how common this is, but it is kind of intriguing. What if you're in the middle of the divorce proceeding, you filed, it's going on, and then you realize, both of you realize, this is really not what we want to do. Can you change your mind?
Yes, you can. It's probably not a good idea to do it in the middle of the proceedings, but it probably wouldn't hurt that much either. But you do have a right to change your mind up until the point that the divorce is granted.
Right.
Once the divorce is granted, then it's a legal court order. You do have 30 days after the date that the order is entered to ask the court to set that judgment aside of the divorce, and then if the court agrees, then you can go back and just forget about the divorce.
Let's talk a little bit about support, child support, and alimony. Let's tackle them one at a time. First, let's talk child support. In general terms, explain how that works, because I know there's a schedule that's applicable that divorce lawyers will use, but the court has some discretion too. Kind of explain that process to us.
Well, we do have Alabama child support guidelines, which are mandatory and have been since about 1988 or 1989. And it's based on the joint income of both parties. Your calculation is you determine the monthly gross monthly gross income of each party. And then you determine the percentage that each party has of the total gross. And then that turns out to be the amount of the support that's going to be paid. If you have 60% of the total gross income, then you're going to pay 60% of the child support. And the guidelines are set up, and they have there's a graduated schedule, and it also involves the number of children and the amount of the income. And then there's a determination of a figure that is the monthly support obligation. And it's the monthly support obligation is the figure that they use the percentage for.
How long does that go? Let's assume once the schedule is set up and once the support responsibility starts, does that go indefinitely through college? When does that end for the child or a specific child?
Well, parties always have a right to come back at some point in time and ask for a modification of child support, just as in the custody. The situation, though, is that it's not quite as easy because there's a rule that says that if you want to file a modification, that's fine. The court will determine what the child support should be. And if there's a 10% difference up or down in what the child support should be or was, then yes, they will get their modification. But if it's less than 10%, they won't.
When a child reaches 19, does the obligation end?
Yes.
Okay. And are there certain responsibilities that a parent may still have through support to guarantee that college is paid for, those types of things?
Yes, the courts have the discretion to, it's not necessarily to say, here, this is what you're going to pay for in the kid's college education. But the trial court does have the right to consider the assets of the parties and then can take figures or whatever from those particular amounts that they determine that each party has and say, you're going to pay this much and you're going to pay that much.
How is alimony determined?
Alimony is a determination is a matter of the need of the wife and the husband's ability to pay.
Okay. Relative to this one is just kind of what's your advice on this, but what do you tell folks in terms of dating again? As you're consulting with them, what's your advice before a couple decide to go out again?
Well, I tell them it's not a good idea if they're still married, because if they're still married, they could really make the judge mad if the judge finds out at some point that we're in the middle of a divorce, but we're dating.
Talk to me just quickly about alimony. I've heard this concept that you have to be married a certain amount of time in order for alimony to even be considered. Is that accurate, or is it within the discretion of the court regardless of the time that you've been married?
Well, and what I found in Gadsden, it's a matter of the discretion of the court. We have judges that will grant alimony at 5 years and some that won't.
So a lot of it will just be dependent upon the education level of the spouse that did not have an income or is it always going to be a circumstance where you have to have, strike that, let me back through that and start over. Is it possible for a spouse that has a job to still get alimony, or is it only going to be a spouse that does not have a job?
It's possible for a spouse who has a job, depending on the income, because the point of alimony is to make sure that the spouse who has the lesser income has or is paid enough to be sure that they have the same standard of living they had before.
Okay. Just a couple of minutes remaining. Just time for final thoughts from the both of you. And Walt, first from you, just what you would leave our viewers with tonight, piece of advice.
Well, the only thing that I can say is anytime you go into a divorce, you have to understand that it is a very emotional and stressful situation. If there are kids involved, you also have to worry about them because they're the ones who are literally in the middle, and as I stated earlier, they're the only ones who can lose in a divorce. And that's the only thing, is just please be careful about what you're going to do. Take care of your children, take care of your emotions, and take care of your situation.
One of the issues we did not touch on, and on previous shows we've talked about common law marriages, and if you are technically common law married because you meet the elements of common law, do you have to go through a divorce? And generally the answer is yes if you want to get remarried again. That's a topic we didn't address. If people have questions about that, they certainly can call, email, or text, and we can get a good answer to it, because there are a lot of people in Alabama that are common law married. But at the end of the day, I think my advice would be you don't want to try and go this alone. You need help. You need somebody to lead, guide, and direct you through the process, manage the expectations, manage the emotions, and handle the legal components. And a guy like Walt Buttram, who has done this for years and is so well known in his area of practice, that's a person you want to go to talk to if you're either considering thinking about it or you're in the middle of one of these circumstances. We hope nobody ever goes through a divorce, but if they do, you want to be with the right person.
I appreciate both of you being with us. Thanks so much for the time. Thank you for joining us as well. We're out of time, but we'll see you next week as we wrap things up. Here's how you can get your questions to us. Would love to hear from you. The firm of Hollis Wright, always available and ready to hear from you. Thank you so much for joining us. We'll see you next week on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.